All right, everyone. Welcome to today's class. I'm excited about today's class. I think last month we had quite an exciting adventure, so I wanted to replicate it a little bit based on your feedback. Thank you for those of you that did the survey. That helps us know what you want to hear about. So based on that survey, the top result was some of these nuanced questions in open meeting law. So today we're going to talk about that. I'm going to provide some case studies to you on what some of the courts have ruled with respect to these open meeting law questions. And also at the end, rather than you guys answering questions, well, you can answer questions, obviously. But at the end, we're going to have a little debate. I have a question in there that I'm going to present my opinion, and if anyone disagrees and is brave enough, they get a debate and see if they can convince the rest of us that you're right. And if that happens, then I'll take you to lunch or dinner or something. All right. Or you just have the pride of knowing that you stumped the attorney in the truest form. Well, anyways, let's go ahead and get started. I always start with stupid laws. I was reading the stupid laws just a second ago. If you've been on for a couple minutes, you see me smiling. I'm smiling for some of you that joined and sent me stupid texts, but I'm also smiling at some of these stupid laws. So I oftentimes skip over a few of these that are not appropriate, but I think in Clinton, I don't know where Clinton is. Is that down south? I don't know where it's at. Anyways, it's a city somewhere. They have a law saying that molesting an automobile is illegal. I assume they mean hitting it with a bat or damaging it, but the word they use is molestation. So there you have it. Here's a few more. I thought this one was funny. It is unlawful to put any hypnotized person in a display window. So I was just thinking, okay, wait, there obviously has to have something have happened in order for that to be law. So I'm walking down, I don't know, New York Street, and I look at these shops with these mannequins in the display window, and some dude has been hypnotized in the display window. Apparently that's happened. That's why we have this law. So, okay, Hawthorne, hats off to you. Don't put people that are hypnotized in display windows. That was stupid. Here's an interesting one. While it is legal to serve alcohol in a pool hall, all intoxicated persons must leave the premises. Okay, so that's funny. I'll do this one as the last one, then we'll dive right into the material. This is hilarious. I don't know if any of you are from Oklahoma City, but if you are in Oklahoma City, apparently they have a big problem with this. So they had to rectify that. One may not tip over a casket at a funeral. Pretty bad. Okay, so as you know, I'm Clint Goodman with Goodman Law, and I'm here to present open meeting law. Because there's lots of you on, I have to say this, nothing I say is attorney-client privilege, so it's in the public forum. Any questions or comments are not legal advice to any community, so if you don't want anyone out there to see it, don't ask it. Sound good? All right. By the way, for those of you attending with your CMCA, you should be getting certificates sent to you after classes. If you did not get your certificate from the last class, please let us know. But meanwhile, this is CMCA as well. So we have the attendance roster, and Christy will be sending those over to you. She's the one with the finger up.
If anybody is sharing a link, please send an email to marketing@goodlaw.legal so that we know the individuals that are using that same link. Should I call out names? I have one name that's logged in 6 times. Petra. So just send
that would be my that would be my lovely team.
Yeah,
which is good. I'm glad they're on. So
I am too.
will make sure I get the role and get it over to you.
Perfect. And I'll make
Thanks,
sure they get the
Christy.
certificates. Thank you.
You're welcome. They get to keep their jobs another week.
All right. Good job, guys.
Awesome. Thanks, Clint.
You bet. All right, folks, let's get started on this. First of all, as you can see from the subject line, you can't do that. We hear that a lot from homeowners. But the bigger question is, can we do it? So, like I said, we're going to dive right into the objectives now. The objectives of this class, we're going to find a few statutes. We're going to talk about them. We really want to dive into the deeper meanings of the open meetings law and what judges are saying. So this isn't technically a beginner course. So if some stuff goes over your head, that's okay. This is a class for those of you that have been managing for a while and have had weird situations happen. Okay, so the main statute, as you know, is here in Arizona. I'm going to just type in 1804. It's the same thing for the Condo Act. But here's the statute. Notwithstanding any provisions in the declaration, bylaws, or other documents to the contrary, all meetings of the members association and the board of directors and any regularly scheduled meetings are open to all members of the association. All right. I'm not going to keep going there, but we know that's the standard. Is the default is every meeting of a board, every meeting of the members, and all regularly scheduled committee meetings are subject to this open meeting law and are open to all the members to attend, except for these scenarios here. When you're getting legal advice, when you're talking about pending or contemplated litigation, when you're talking about the personal information of a homeowner, when you're talking about job performance, compensation, health records, specific complaints about employees or employees of the contractor, and then lastly, members' appeals, unless they ask that be held in the open. So we should all be on the same page right now. That's the standard stuff. Now let's talk about the application of that law. So let's start easy with scenario one, and we'll work our way through to the last question where we have the debate. Number one, 2 of 5 directors meet on site with the landscaper to go over the board's concerns. So in this scenario, it's the typical, hey, the board met in an open meeting, and or even in an executive meeting if it was talking about pending or contemplated litigation against the landscaper. And the board basically is concerned about what the landscaper is doing and what the landscaper is not doing. So in this scenario, then 2 of 5 directors meet on site with the landscaper to go over the board's concerns. Is that okay? Yes or no? Is that an open meeting violation? Well, if we look at this plain language of the statute, there it is. No, there's not a quorum of the board. Now, if we want to dive into one layer a little deeper, we're going to do that in just a minute. When a board member may meet with a landscaper, or a couple of board members may meet with a landscaper without board approval, that's a totally different question. That's an authority question. That's not today's class. Today's class is open meeting law. So all I'm asking is there an open meeting law violation? I'm not asking if it was okay. Because frankly, and I'll just say this before we move on to this scenario, the next one, if 2 board members of a 5-person board meet with a landscaper, it's not a violation of the open meeting law, but what if they don't have authority from the board to do that? Then obviously they're in breach of their duties potentially. And that's a different question and answer for a different day. All right, so let's go back to open meeting law. So no, there's not a quorum of the board. And if you can recall from the statute, it says very clearly that you have to have a quorum of the board. And if a quorum of the board meets together, even informally, you may be subject to the open meeting law, but we don't even hit quorum. So that's nice. Okay. Now here's the scenario 2. 3 of 5 directors meet on site with the landscaper to go over the board's concerns. Now, is this a violation? Give you a second to think about it in your brain. Maybe, let's see what the answer is. It depends. We love that word, right? So let's walk through the analysis. Number one, is it subject to the open meeting law? So, well, first of all, we know it's subject to the open meeting law, but the bigger question is this something that the members have to be able to attend and comment? And I think most of the time the answer is probably going to be no, because what happens if it's a board concern about how landscape is being done? I don't typically like to see a quorum meet with the vendors on site. I think it's a bad idea, but some are adamant that they do it. And so I have to be able to craft arguments to say it's not an open meeting law violation. What are some of those exemptions that allow us to meet without the members? Well, the catch-all there is subsection 2, right? Pending or contemplated litigation. Contemplated is a very broad standard. And if the board has a huge concern about the landscaper and they're contemplating what that could mean from a litigation perspective, then there's a good argument that that quorum could meet with them as a close. But that does subject you to what the statute also says, that before a quorum of the board meets, even in executive, you have to let the members know what subsection of the statute's authorizing them to meet. Okay, number 2, that's what I was talking about. Is there an executive subsection? And remember, if you have a quorum of the board meeting to talk about association business, on-site, off-site, via email, via Zoom, chances are it's going to be an executive. Hopefully, if they're not making decisions to approve rules or enter into contracts with the landscape company. But if they're talking about concerns they have, chances are it's under that subsection 2, which is executive subsection. But like I said, you have to ensure that the members are aware of which subsection is allowing them to meet. And there are a few other exemptions, but we won't get into those right now. Now, so that goes to number 3, obviously, about sending out the email. Now, here's the next question. I'm not going to go on to scenario 3, but I'm going to create a scenario 2.1. Must the board wait 48 hours to meet with that landscaper in this scenario? It's executive. We're just going to assume it's executive because they need to talk about their concerns and resolve their disputes with the landscape company, because they really are seriously. We'll just assume that contemplated or pending litigation piece applies here. Do they have to wait 40 hours? So in other words, can they email you in the morning and say, we're going to go meet with the landscaper today at noon. We need you to just send out a blast to everyone that we're meeting pursuant to A2 of the statute in executive with a landscaper. Is that okay? Do they have to wait 48 hours? Are you going to tell them they have to wait 48 hours? Let's look at the statute for a second here. We know it says at least 48 hours here. Make sure I'm doing the search here. Let me see. Notwithstanding any provision in the declaration, bylaws, or other community documents for meetings of the board of directors that are held after termination of declaring control, notice to members of meetings of the board shall be given at least 48 hours in advance of the meeting by blah, blah, blah. So what do you think? This is an executive where owners can't attend or aren't going to attend. Does this 48-hour requirement apply? Some, if you ask, it depends on who you ask, I think, because we don't have case law on this yet. This is one of those fun ones. We're like, here's my opinion. My opinion is that the 48-hour notice requirement applies because you're dealing with owners and their desire to come attend and comment and listen to what's going on. If that's no longer an issue, all you have now is an executive. So what does it say about the executive? Oops. Let me get rid of that just today. All it says is before entering into any closed portion of a meeting of the board of directors, you just have to identify which subsection. So let me give you another example. Let's head off the landscape scenario. We're in an open board meeting. This just happened to me because I'm on my board. We're in an open board meeting and something comes up in the middle of the meeting. We have an angry owner that's screaming and yelling they're going to sue over something we had no idea. It wasn't on the agenda. It was just during homeowner forum. You guys all have that happen. If you've been in this space for any length of time, we're in the middle of the open and you're like, in your back of your mind, you're thinking, well, we need to adjourn into executive after the open meeting to talk about this. Well, if you didn't give the 48-hour notice to adjourn into executive, then you're toast. But this is why subsection C exists, because me as chair, right before we adjourn the open section, I tell the membership, thank you for coming. We're going to adjourn the meeting. Well, is there a motion? Blah, blah. Then I'll just say we're going to be adjourning the meeting and going into executive pursuant to ARS 33-1804 A1 and A2. And then we do it. There was no 48-hour notice. And I think a lot of you probably do that when things like that come up. Is that a violation of the open meeting law? Do you think a judge would say you are violating the open meeting law? I say no. I don't see that as a violation by any stretch of the imagination. So it would be impractical and it would be procedurally a huge, massive cluster. You'd never get anything done if you always had to wait 48 hours notice. So with that same analysis, let's go back to the landscape question. Can you just send out that email to the membership saying, hey, the board's meeting executive today pursuant to A1 or A2? I think you can, based on that analysis. Now, the caveat there is we don't have case law. So who knows, maybe the Court of Appeals might create some case law on it, but you can see the argument that I just made is a good one, that the 48-hour notice requirement applies to open board meetings, not executive. Okay. All right. So I know there's some chat. Let me look and see if there's any additional questions before we move on. Give me a second. Oh, you guys are answering the questions. Awesome. And I love it when I see smart people say something and they're right. Okay, fantastic. Okay, let's go on. Here we go. Scenario 3. Rather than approve a contract with a roofing company in an open meeting, the board approves it via email with unanimous consent. We see this happen. It's in play all the time. I see it a lot. Is that a violation of the open meeting law? So let's find out. I'm going to put no and yes, but let's talk about it. So we have this action in lieu with unanimous written consent statute, right? So when we go to that statute, it says this. Requires the consent of one or more people. Action without a meeting. All right. We know that if it's taken by all of the directors. Now, this is the Nonprofit Corporation Act, and that's so if you're just talking about the Nonprofit Corporation Act, the answer is yeah, you can approve that contract with unanimous written consent, and unanimous written consent of the board is email. That's fine. But what about the open meeting law, where it's very clear that all meetings are open to the members? And then it goes on, as you've read out before, that before the board can take formal vote, they have to allow the members to comment and yada, yada, yada. Is there a conflict between these two statutes now? Maybe. I think there is. Arguably, I mean, we've all heard the arguments if you've been in the space for any length of time. And frankly, the majority of us HOA attorneys say that action in lieu may not apply, but there's certainly the argument that you can still do it. And until we have case law from the Court of Appeals, there's always going to be a risk. Now, having said that, there are times when I approve things as a board member via email. Is it technically an executive item? No, but for purposes of efficiency's sake, we absolutely just do it. If it's a big decision or something that's going to impact the members, we always do that in an open meeting after comment. But there's like what the law says, and then there's what you do. And I think there's a good argument that yes, you do have a conflict between these two statutes. Yes, I think that most judges are probably going to interpret the statute in favor of open meeting law, especially if it's a big decision. But we don't have case law on it yet. I know several attorneys that in the HOA space that are convinced that actions in lieu are not trumped by this statute, and there is no conflict, and you can do actions in lieu with written consent whenever you want. But I think that if you ask the number of us, you'll probably think the majority of us say actions in lieu can be a violation if it's the board that's doing it. And speaking of that, here's a case study for you with the Department of Real Estate, with the risks of option one, which was doing the action in lieu. In this case, Judge Lowe, this is a while ago, by the way, from 2017. Judge Lowe made the decision or held that a board that approved a contract via email, unanimous written consent, violated the open meeting law. Because what happened there is that board approved the contract via email with unanimous consent and then ratified it in the next open meeting. When they ratified it, a homeowner there got wind that it was ratified and already decided. So they freak out and they sue in the Department of Real Estate. And it goes to the hearing, and Judge Lowe agrees with the homeowner, says there's a violation of ARS 33-1804. And then not only just didn't stop there, sanctioned the board $1,000. So that is a Department of Real Estate case. Now, there's a caveat to that case. That board did not want their attorneys to represent them as a DRE. They went in themselves. They had one of their board members, if I can recall correctly, thought that they could just handle it on their own. They didn't want to spend money because they know at the DRE you don't get your fees, and they didn't have insurance coverage for it back then. So I don't know. I mean, if I argued it or another HOA attorney argued it, I think their chances of winning would be greater. But the bottom line is Judge Judy Lowe said, no, it's a violation to do actions in lieu for contracts. All right. So that is a good example of where we are at with that particular issue. Scenario number 4. What would you do? The ARC reviews and approves all ARC applications via email as they come in. Is that a violation of the open meeting law to do it via email, ARC applications or DRC applications, whatever they are? You know what I'm talking about. I say, nope. Why? Because the open meeting law actually carves out a specific and express area dealing with committees. And it says just that. It has to be regularly scheduled to be subject to the open meeting law. So if the ARC is getting emails just as applications come in, it's not regularly scheduled, it's just ad hoc, just happens as they come in. So this has actually been litigated at the DRE. I tried to find that case, I couldn't find it. I know it's out there, and well, I shouldn't say I know, maybe it's not, and I'm just hallucinating, but I'm almost positive there's a case of the DRE. And if any of you were involved in that one, just maybe chat or send me a text or something. But the bottom line is the DRE, assuming there was that case, agreed 100% that there's no violation with the ARC is approving things via email as long as they're not regularly scheduled committee meetings. So that brings us to our next question. The ARC and the board are one in the same. So this is like, you've got 3 board members and the 3 board members are also on the ARC, right? Sometimes an ARC's different from the board, but for efficiency's sake, I know on my board, we like to be the ARC too, because we don't want a separate body approving things that could create liability for the association. We want to control the ship. So sometimes CC&Rs require they be separate, but if they don't, you all know, lots of times ARCs and boards are the exact same people. So this is the question, is that if you are a board member and an ARC member, and you're looking at that application, is there a quorum of the board now? And are you subject to the open meeting law? What do you think? I say no. I'm going to tell you why. But before I do, I want to know if any of you want to make the argument that it would violate the open meeting law. Anyone brave enough to do that? Paige, you always love to argue with me. Do you want to make the argument, or do you agree with me? Oops, hold on.
Sorry. I could go either way on that, but for fun, yeah, I would say it's a quorum of the board, even if they're just looking at an architectural application.
Why? You got to give everyone a reason why. You just can't say your
Because
conclusion.
it's a quorum of the board.
Convince us. Is that your argument?
Well, yeah, because it's a quorum of the board. It's a weak argument, I guess.
All right. Anyone else want to support what Paige just said?
I'm going to add to Paige and say that if they have regularly scheduled meetings, then it would be a quorum.
Yeah, it's a no-brainer for this regularly scheduled committee meetings, because the open meeting law says it doesn't matter if you're a board member or a committee member, you have to do it in open. So it's a moot point. So yeah, I see a couple comments to disagree with you, Paige. All right, here we go. Let me tell you what I think. So Paige, do you live in an HOA? Now, let's take you off mute real quick here.
Yeah.
Are you on the board of your HOA?
No.
Okay, let's assume you are on the board, all right? So we're just going to say you said yes for the
Okay.
sake of this argument. So you're sitting at your home and you get your beautiful statement from your management company, and you pay your dues on a monthly basis. As you're sitting at your desk in your home or your kitchen table, and you're getting ready to cut that check or do whatever, are you paying as a board member or as a homeowner?
As a homeowner.
Yeah. Are you paying as a board member?
No, so I get where you're going with that. Then the 2 separate hats comment that Tracy meant,
Yeah.
you convinced me.
Oh, wow. I didn't even have to make the argument. You're already convinced you're wrong. Well, I'm just saying, like, so let's just play that through for a second. So
Yeah.
You're sitting at your kitchen table as a homeowner, you know, you have to pay your assessments. You have a duty to pay your assessments. If you didn't, you know, the board's going to sue you, and the board is a different person entirely than Paige. You have like a personality defect in that you've got 3 personalities going on. If you're a homeowner, if you're a board member, and if you are a committee member. So now let's fast forward, because you all are hopefully through budget season so far, right? It's the end of the month. You've all got your budgets out there. You're done. Your boards have reviewed them. I hope so. So let me share with you my example from last year when I got my budget for 2023 in October of 2022. It was a doozy. There was going to be a massive increase because of all the capital improvements we had this year.
Hmm.
So I'm sitting there as a homeowner, and my first thought is, well, dang, that's a lot of money. I don't want to pay that. That's my homeowner hat, right? I have to take that off and put my board member hat on and say, well, what's best for my corporation? My duty now isn't owed to myself, it's owed to the corporation. I have a fiduciary duty to act in the best interest of the corporation. I'm a different person entirely, technically. So the bigger question now is, when you're sitting on a committee looking at an architecture review application, is there a difference between the committee member and a board member and the duties, the respective duties? I argue yes, because the statute was already very clear. There is no question. It says the committee meetings are only open if they're regularly scheduled. So do we have a committee of the board or a committee of, oh, I'm sorry, not committee. Do we have a quorum of the board when reviewing only the ARC application, if all of us are board members anyways? Or do we have a quorum of the committee when we're only reviewing architecture review applications? And my point is, we're only dealing with a committee because it's a totally different duty. The CC&Rs even specify the duties of a committee versus a board, and says the board can appoint committee members. So it's already bifurcated, even in your governing documents, the difference between a committee member and a board member. Just because I'm the same person doesn't mean I'm bound by the exact same laws. Now, I do know that there's some pretty compelling arguments that some attorneys have made that you can't separate the two, but I have to say I disagree with them. And I don't just disagree with them, I think they're flat out wrong. That's just me. And until we have case law, you know, I might be wrong. Who knows? I mean, Callaway came out of left field, right? So who knows what the Court of Appeals and the Supreme Court are going to do if they get a hold of this issue. But I really think that for purposes of efficiency's sake, you can only imagine how much of a pain in the butt it might be to always have to do a meeting, because you got a quorum of the board reviewing applications. Now, I will tell you that it has to be limited in scope only to the committee function. Sometimes if you're on the board too, it can get really easy to go outside the scope of a committee. So I mean, you get an application and then one thing leads to the next, and before you know it, you're talking about landscaping issues in the community, or you're talking about raising dues in the community for next year. That's outside the scope, right? If I'm talking about whether we should raise dues, I'm not talking as a committee member anymore. I'm talking as a board member. So the committee hat goes off and the board member hat gets back on. But you're right, Paige, we do need to lobby our judges. All right. Dave asks, let me go to some questions here in the chat. Dave asks, could I please get scenario 3 in written form with the result? I may need to use that in the future. Was that the DRE decision, I think? Hold on, let's go back to scenario 3. Yeah, okay. Sure. Do me a favor though, shoot me an email. I got permission from our client, because they happen to be a client of ours too. That's how I know that they didn't want us to come represent them. I did get permission from them to disclose their name, so and that ruling. So I can send that to anyone that wants it. Just shoot me an email. I'll pull it up and I'll email it to you. Yeah. I don't think. Does anyone else want to say? Now that we've talked about this committee board thing, does anyone want to say I'm wrong? I'd love to hear it. Otherwise, don't be scared. Don't be scared. I'd love to hear other opinions. And you know, I'm wrong all the time. My 14-year-old girl, you'll probably all meet her in a couple of years when she gets out of law school. I can never convince her I'm right, and she's always right. Doesn't matter what the argument is. She loves to argue with me, and she's always right. If she was on here, she'd tell me why I'm wrong. Maybe next time I'll have her join as a guest speaker to tell us all why we're all wrong. All right. Well, that concludes today's session. You get an hour of credit because of the continuing education credit and course. So good. If there aren't any other questions, let me just do this real quick before we conclude. All right, there are a few questions. Can a board approve meeting minutes via email with each other prior to the next meeting and skip the approval process during the next meeting outside of saying the minutes were approved via email by the board? Jill, email me direct on that one. It's probably a question you want to bring back to your board. And I don't want to say anything now that would be public and a homeowner could grab if they want it. So shoot me an email.
Okay, thank you.
Yeah. Jocelyn asked the board approves the ARC guidelines and rules of the association and are enforcing them when deciding the applications for architecture requests. Couldn't this pose an issue? Committee members now no longer acting as a committee member, but acting as a board member. Yeah, it's a great question. That's exactly what we were just talking about. So, and I'm really glad, Jocelyn, you brought that up. So if you're only looking at the application for purposes of approving or denying it, okay, you're a committee member. But if you start talking about, okay, we're going to deny this and they're going to keep moving forward, we need to sue them now. Or how are we going to sue them? Or how are we going to get them to stop? You're not talking as a committee member now, because a committee does not make those decisions. You're talking as a board member. And now you're clearly within the open meeting law. The next question is, okay, if we are in the open meeting law space, is this an executive issue? Yeah, A2, pending or contemplated litigation. But did you send out the subsection notification before you went into executive? So if you didn't send out that subsection A2, then I'd say, don't talk about anything other than just the committee. That's it. Let's see here. Who decides attorney-client privilege? Ooh, good question. I have a board member who thinks the board should decide. Attorney-client privilege, generally speaking, is, well, let me just say what it is and then who holds that privilege. Attorney-client privilege means that anything you tell me as your attorney for advice is secret. And it cannot ever be disclosed by me, not to I can disclose what those secrets are to the rest of my firm because we work together to give you an answer to that secret, but it can't be disclosed to my wife. It can't be disclosed to my children. It can't be disclosed to my BFF. It is a secret. The only time I can disclose your secret is if it's going to cause serious bodily harm or death, and I have to notify the authorities. So if you come to me and say, hey, how can I abuse my child because I've been abusing them and I need to come up with ways that I can legally assault them because I want to do it in 2 hours. How do I do that? And they're asking an attorney, maybe a criminal law attorney. I'm not a criminal law, but that criminal law attorney better be notifying the authorities. So the privilege, who holds the privilege in our context? I don't hold the privilege. I can never waive it for my client. The client holds the privilege. So the board can technically waive that privilege if they want. And that can get a little scary because sometimes when they waive that privilege, sometimes you might see an opinion letter from an attorney in a lawsuit. And then it's hard to prove, make another argument if that's the case. Speaking of privilege, one thing that I want to make it super, super clear, this is a training issue for all of us because this just came up with us and our attorneys and our ethics council yesterday, actually, in the context of HOAs. So if I give advice to somebody during free legal or right here, it's not technically advice. It cannot be advice. So if you have like a question when you meet with me in free legal or here in this setting, unless I know A, who the client is, and B, that I'm their attorney, whatever I say may be subject to disclosure by the homeowners. And that can be a little scary. So it's really important that if you have a secret and you want some advice about the secret, and when I say secret, it's not a bad connotation, it's just something you want advice on without all the entire community to know about. You need to make sure there's that attorney-client relationship first and that you're actually giving legal advice. All right, cool. My board says they can discuss things in executive session prior to adopting a contract that it has no issues. I tell them that is not under the qualifying items of executive session, and I'm picking my battles. Yeah, Dawn, this is a tough one because on the one hand, you've got concerns about that. You've got efficiencies issues. I mean, if you go into an open meeting and you're talking about all the nuances of a contract and what needs to be revised here and there and everywhere, you may have to table it, and you may have to table it again. And then before you know it, you're 3 months out and you don't even have a contract with the vendor yet. So this is a tough one. I know lots of boards out there that will get together and talk about terms of the contract to get it whittled down. The safest thing to do to avoid a judge at the DRE to say you violated the open meeting law, like Judge Judy said, or Judy Lowe. I think keep it under quorum, and maybe designate your chair or somebody else on the board that has knowledge about that contract to work out the details with the manager, and then present it to the board in an open meeting. Once those details are worked out without quorum, then you're safe. That's the simplest thing to do and the safest thing to do. Otherwise, you're in a gray area. All right. If one board member requests info from the HOA attorney, must the answer be provided to the entire board? If one board member requests info from the HOA attorney, must the answer be provided to the entire board? No. Pam, you're wrong. No. Let me give you an example. You remember that McNally v. Sun Lakes case? Remember that, what happened there? This was years ago. Miss McNally was on the board. She was disclosing executive packets, collection reports, from what I understand, executive reports, all of the executive packets you give. She was just giving them to people, making copies and handing them out to the community members. Violations, delinquencies. I mean, the hair on the back of your head should be standing up, right? The board freaks out. The board needs advice on what to do about Miss McNally. Do you think Miss McNally has an absolute right to be in that meeting to hear what the attorney says about the action that the board can take against Miss McNally as a rogue director? Absolutely not. In fact, McNally, she won the case because the board did it wrong, but not because they excluded her from board meetings, because they just kicked her off the board. But the Court of Appeals in that decision was very clear that there are times when the board has to be meeting without a board member, and that would be a perfect example. I just had that come up yesterday, not because a board member was rogue and spreading executive information, but because that board member was screaming and yelling and having a complete psychotic meltdown and scaring everybody in the community. And cops came out. So the board had to meet and talk about what they needed to do, if anything, in addressing that one board member that was verbally accosting members, harassing the vendors on site, trying to get the vendor to amend their contract, to do a bunch more work that was not approved by the board. Yeah. So if you need advice on how to deal with one board member or a rogue director, the board can absolutely meet an executive without that director and keep that information from them. Okay, so as far as all board members being allowed to communicate with the HOA attorney, well, what about that? I say this is corporate law. This is more of a corporate law question. If all board members could reach out to me and talk to me, I do not like that. And I always say, no, why? Because if the board, I have this happen quite a bit, and you probably do too, when one board member hates another board member and they're going to reach out to me to talk about how much they hate the other board member and what they can do to kick that other board member off. Am I giving advice to the board then, or am I giving advice to an individual? I'm giving advice to an individual. That would be a complete conflict for me, because I don't represent individual directors. I represent the board. So typically the board, they appoint you, the manager, to talk to me. And I like that. That's the way I prefer it. Now, if the board wants to appoint the president or somebody else on the committee or on the board to talk to me about something, absolutely, I'm totally fine with that too. And as you know, oftentimes if it's a general issue, we will email the entire board or email you and then copy the entire board on an opinion or whatever. I don't have a problem with that. But what I do have a problem with occasionally is if everyone on the board reaches out, because it creates this potential issue for me, and I have to shut them down pretty quick when they come to me and they have a problem with another board member. Or it creates a much higher bill by the end of that month than what it should be. So yeah, great question. And all right, are there any other questions? Because if not, I think we had a fantastic session. Hopefully each of you learned something. This has been recorded, so it will be posted online for any of your friends that may have missed this session that need an hour credit. So thank you, everyone. Really appreciate you joining. Until next time, bye-bye.